judgment in the Fabregas matter.
Yes.
Now, you mentioned in explaining your curriculum vitae, there were 5 areas that you gave interpretation in this matter, and that was basically handed into court. I'm quoting from the record. Those were your words, meaning on those 5 areas, the court accepted your evidence, because you also said you didn't testify in that matter, but because my evidence was admitted. Do you understand correctly what you were telling the court here?
Yes, what I said at the time when I did my CV, the understanding of the case from Advocate Botha was that the report was handed in and that there was no need for me to come through and testify. That's what I had. But the judgment was given subsequently. I now read the judgment and I now see differently in the judgment by the Honorable Judge Desai.
So, to understand you then, these 5 areas that you thought you covered, that was admitted, but that was based on the explanation by Advocate Botha.
And if one looks at the judgment, my lady, and the paragraphs that were referred to yesterday on page, for example, page 139, it says here, during the cross-examination of Dr. Anthony agreed with the contents of paragraph 6.4 of Dr. Reggie Perumal's report, which is here, Exhibit QQ, and says, according to the report, Rudy lay on the bed for a while, probably as a result of a concussive state, taking into account the pool of blood on the bed. It was highly unlikely that he died immediately in an unconscious state. Dr. Anthony testified that there was no injury that could have rendered Rudy immediately immobile or causing death soon after sustaining the injury. It was very likely that Rudy was capable of physical activity after being injured. He might have been disoriented from a probable concussion, and his vision might have been affected. Rudy would have been blind in at least one eye. Dr. Anthony responded that she was not at liberty to absolutely dispute the time period of 2 hours and 40 minutes for Rudy to die. But one had to take into account the blood loss. Dr. Perumal never testified, and therefore that opinion wasn't considered. So I didn't go and testify on that aspect. That's how I read this now. So that was put to Dr. Anthony at the time that she testified, and she didn't really have an issue with it. Yeah.
But as I understand this judgment and your participation in this whole trial, Dr. Perumal, this paragraph 6.4 that's now before this court, Exhibit TTT, that was the only part that was accepted by Judge Desai in the end as evidence, where it coincided with the evidence of Dr. Anthony. Is that a fair summary?
No, that's not how I saw it. I saw that that's where there was, the judge was saying I should have come and testified further, but I wasn't called.
Well, if we look at the judgment, page 166, that I also referred you to.
Yes.
And I quote, despite the fact that Dr. Perumal advised the defense counsel on self-inflicting injuries and his presence in the court, no expert witnesses were called by the defense on this vital issue.
That's right.
Including yourself.
Yeah, I didn't, in this report here, which is now Exhibit TTT, I didn't, my lady, go into the issue of self-inflicted wounds on this report. I didn't comment at all on it, and neither was I asked to come and testify on it.
I accept that. But what Judge Desai found was you advised the defense counsel on self-inflicting injuries. And that was an aspect placed in dispute. Although it is not contained in your report,
Yes.
you were present you recall, when Advocate Botha questioned this aspect and put it in dispute with witnesses called, or witness called by the state.
My lady, I'm accepting. I was present when the witness testified. Advocate Botha put certain questions to the witness. I personally didn't give a comment or an opinion on the self-inflicted wounds, and I think I'm not at liberty to say what my views were at the time and why I didn't testify, but I see what's written here. I don't know whether I could say what my thoughts were at the time on the self-inflicted wounds, but I didn't testify on it, neither did I comment on it. I steered away from writing about the self-inflicted wounds.
And you accept you're not qualified to comment on that?
Yeah, because I don't have any further knowledge. I don't claim to be an expert. It's more the field of clinical individuals rather than a pathologist.
Then the last aspect of the judgment that I want to refer you to, page 270, where the court found, dealing there with a witness that was confronted by State Counsel with Dr. Perumal's opinion to the effect that Reggie would have been able to make significant movements. Of course, the witness spoke of limited movement. There was a dispute there, correct?
That's correct. Yeah. I said he was capable of making the movement from the bed down to the floor, and even a little bit further, because he didn't have any injury that incapacitated him. That's what I said.
Okay. But that opinion was not accepted by the court.
The fact that it was significant versus minimal. Yeah, I think the point I was going to make was that the individual was able to move from the bed to the floor and from the floor a little bit forward.
Thank you. Now, let's move to the Oscar Pistorius trial, and do I understand your comments there correctly, that you said in this court that you were involved in the retrievement of a
Projectile.
bullet or a jacket? What did you say now?
No. It's a projectile.
Yeah.
Yes.
And from your memory, that is how you recollect your involvement there. You went to the scene and you retrieved this.
No. My lady, what had actually happened was that I spoke about in the context of the post-autopsy scene visit. There's a lot of value in visiting the scene after you do an autopsy. What happened in this case was, it was clear that one projectile had exited the body, and it was clear to me that the police who examined the scene would have retrieved a projectile. From those that were found in the body, it was clear it was a black talon, and I don't want to go into the detail except to say that it's designed to open up in the body, but this one didn't. It went through. And when it went through, it would have lost a lot of its energy, velocity. And I knew that that would have been at the scene. So that was discussed with counsel after the autopsy. Explained to counsel. I think that was on the Monday night, but on a Tuesday, I went to the scene. And when I went to the scene, the door wasn't there, but I could see an impact mark on the tile. And when I saw that impact mark on the tile, I commented to the team that there would be a projectile in the toilet bowl which was filled with blood and hair and brain tissue, etc. But because of my sense, I didn't want to touch that projectile because there was a ballistic expert present. And I said to him, because of the chain of custody, I said to him, there is a projectile in there, just fish around. That was removed and maintained the chain of custody, and I can't recall exactly, but I think the next morning he gave it to the investigating officer, but I could be wrong. He may have given it to the ballistic expert for the state, or he could have given it to the investigator. I wasn't involved with it from then. All that I did was looked at the body, looked at the scene, and made the comment about the projectile. But I didn't personally pick it up because I didn't want to interfere with the chain of custody. That was my involvement in that setup.
Because what I recall from your testimony here in chief was that you personally took it out.
No, I don't think, I'm not sure if I said that, but if I said that, then that's not correct. But I was involved in the location, in the assessment, in terms of the post-autopsy scene visit. That's what I said.
In that the state is at idem with you, that there
Oh.
was consultation with the defense, Advocate Baru at the time, you were involved and other people, but, and I want to refer you to the record in fairness, my lady, my hand up, an extract from the type court record in this matter, and I'll identify it now properly.
Yeah.
It's the court record of Quo Victoria. What I've handed up, it starts on page 2321, line 20. Now, Mr. Vormerans, although what the court has got is pages under left bottom page, it's marked 1 up to 7. Now, it's Mr. Vormerans was a ballistic expert who testified. Do you recall him?
Yes, he was at the scene with me.
Excellent. Now, just the background there, he started off his evidence led by Advocate Roo. So there were two major disputes. I'm there in the second paragraph of the first page. This extract handed to you now.
Yes.
At the bail application, whether the accused, Mr. Pretorius, was on his prosthesis when he fired, and secondly, whether he stood approximately 1.5 meters in front of the toilet door. Then, but later in this page, I will fast forward for a moment before I come back to it. These disputes have since been overtaken by a report by the state. And then it's additional matters that he's going to testify on, and specifically what you've now raised. And if we can then turn to page 5 of this document in front of you, Dr. Perumal.
Yes.
At the bottom, and that is on the record page 2327, line 1. And at the bottom of the page, it starts with, can you deal then with the investigation? That's the question put by the group to Mr. Vormerans. You've got that?
Yes, I
Good. Now, he says in his evidence, I first arrived at the alleged crime scene on the Sunday, the 17th of February, after it had been released by the police to me. At that stage, the alleged crime scene was secured by Platinum Risk Solutions. I did a walkthrough on the crime scene, my lady. I also took photographs. Mr. van der Westhuizen was present, took photographs. Ms. Amelia Grissel and Estelle Pieters from CSI Africa arrived approximately 1740, entered the alleged crime scene. Later on, at that page, the door had allegedly been removed for purpose of safekeeping, and on the 18th of February 2013 at 2144, I removed a fragment of a bullet found in the bathroom toilet bowl.
That's correct, yes.
Yeah. Now,
He removed it.
okay. Nowhere on this record can I find your presence, just from reading this.
I'll accept that there's no way that it is. I can't argue with that, but what I said to the court about my assessment, that I stand by.
Okay.
That I am the one who looked at the impact mark on the tile and then into the toilet bowl. So I didn't personally, physically, it would have been incorrect for me to do it if there's a ballistic expert present. I didn't want to interfere with the chain of custody. So that's really the issue.
All right. You just gave guidance to the team, as you now explained.
Yeah, in a sense, because of my assessment of the scene.
Hmm.
And it's correct that he picked it up. He's the one who retrieved it.
Right.
So I don't argue with this really.
Let's move on. My lady, exhibit PPP. I've handed the full extract, 29 pages, all the footnotes, ready to the defense this morning. I would like the court also to have,
Is that the article?
that's the article, and for the witness. Dr. Perumal, is there anything else, and I'll give you enough time, you don't have to respond immediately, that you would like to have a look at in this article? Yesterday only the extract was put to you,
Yes.
and the page 11, that's the second page.
I mean, I've just got it now.
Now, as I say, you don't have to comment now, but we can get to it later if there's
Page
anything.
13 of this article, I see that the determination of alcohol in body fluids, right on the top, my lady, you'll see there's a column there saying table 2, tells you, for example, the various fluids that you can use. And one of them I said was vitreous humor when the body is decomposed. And then if one analysis of vitreous humor on page 16, paragraph 6, again just reaffirming that we use that very often in cases where there's mangled human remains because the eye is protected in its socket and we easily access that, but we have to use the conversion factors. Then on page 20, paragraph 10 confirms the post-mortem diffusion, because I said that if somebody takes alcohol, consumes alcohol, it's still in the gut at the time of the death, you can diffuse into the nearby blood vessels. And I mentioned about drowning and decomposition. And I think somebody highlighted on page 22, under the conclusion,
Yes.
first, second, third. The phenomenon of post-mortem diffusion and redistribution means that the concentration of drug determined at top C blood is not necessarily the same as the concentration of blood at the time of death. And I agree with that. It will depend now on the amount of time that has elapsed. I'm just trying to see if they tell you in this article that if you take it within a short space of time in the post-mortem interval and the body is properly refrigerated, that you can actually rely on that result. Otherwise, post-mortem blood alcohol will have absolutely no value if that were not true. I don't think there's anything else here.
Would you agree, still on page 22, right bottom, with the following as stated there, a person's BAC, blood alcohol content, should not be interpreted in a vacuum.
That's correct, yes.
The totality of information gleaned from toxicology and interviews with witnesses,
Yes.
police reports, etc., are important considerations.
Yeah. That when I think the aspect of the interview with witnesses, the relevant aspect will be when somebody consumed it, because you want to know whether the person is still on the ascending limb, whether they're at the peak, or whether they're at the descending limb. So that's the relevance of the interview with the individual.
So, in general, whether you've done a first autopsy or a second autopsy on whose behalf, you may wait with your final report, for instance, this is an example why you would wait. You first would like to see other witness statements, discuss it with the IO, what is happening with the investigation, etc.
Yes, my lady. What I did was, in that comment that I gave, I said that I was informed that the last drink was probably around 0200 hours. And I used that information. I was informed that she did consume some alcoholic beverage, and I was informed about the time. So I worked on that. But if there's any other variables, I can always factor it in now and express an opinion.
Right. Now, I want us to deal with the post-mortem of Dr. Khan, specifically paragraph 9.12. Do you have his post-mortem there in front of you, Dr. Perumal?
Yes, yes, my lady.
On page 6, extraction. The issue of fractured ribs and the blood in the stomach.
That won't be in paragraph 9. Paragraph 9 is always the neck structures.
Yeah, indeed.
Paragraph 10 will deal with the ribs.
Yeah, thank you. Now, the blood found, as I understand your evidence in the stomach, you relate it to being CPR.
Not in the stomach. No, I was very clear that the blood in the stomach and in the small bowel, the source of that blood would have been, in all probability, an injury to the nose.
Caused by?
The injury to nose would have been caused by blunt force trauma, blunt force injury.
Would it have been anterior or posterior nosebleed?
I can't speculate. I can only say the following. She must have had some injury to the nose because there's blood. One of the pictures of the scene show clearly that she's got blood in her nostrils. If the court wants, I can find that picture. But clearly she's got blood in her nostrils. Now, that means she would have had some blood loss anteriorly, and if one looks at the scene, there's some blood in the bedroom on some of the, the sheets or pillow, and that could be one source of the blood anteriorly. My opinion is that the blood that's also gone posteriorly, and she swallowed it, and it's gone down into the stomach. I went further and I told the court that because there's blood, altered blood in the small bowel, and fresh blood in the stomach, with a clear space in between of the intestine not having blood, that must have been 2 episodes of swallowing of blood. So I can't tell the court where exactly the injury is.
Fair enough. The question is, when was that injury sustained posterior, so that she swallowed blood and, well, let's just deal with that statement.
Okay.
Or question.
All right. My lady, once again, it is very, very difficult to tell the court precisely when that happened. That injury was sustained. Now, what I can do is guide the court in terms of the fact that it could not have happened at the time, at or close to the time that she died.
Why not?
I'm waiting to explain. My lady, because the blood has already passed down the esophagus, it went to the stomach, and it doesn't pass straight away. It spends some time in the stomach, and then it gets altered in the process by the gastric acid and goes now through a segment, and I don't know how far it went, but we know that it's not in the immediate proximal small bowel, but it is in the small bowel. So I don't think anybody can predict the gastric emptying time and how long it will take for that blood now to leave the stomach and get to the, let's say, I can't say whether it's a proximal small bowel, but it's not really proximal, it's just distal to the proximal. So that time I can't say, Malay. There's so many factors. If you say, can I say it's half an hour? I'll say it's consistent with half an hour. If you say it's 1 hour, I'll say it's consistent with an hour. But what I can say is that it is not at or about the time of a day.
Okay.
She could have swallowed the fresh blood, the blood that is fresh in the stomach, which I will call the second episode of swallowing. That could have happened at or about the time of a day.
Now,
Close to it.
let's unpack this a little bit. Photograph 165 in the post-mortem.
Sorry, Malay, paragraph?
Photograph
Oh,
in the post-mortem of Dr. Khan, 165.
yes.
Floating takes place. You perceive that?
Yes, the intestines are slightly distended. Now, I don't think I must consider this pathological.
Why not?
The reason is, if one looks at the photographs of the Mrs. Rohde at the scene, one can see that the abdomen is reasonably flat. Now, if there is significant, sorry, Malady, I'm rushing along. Malady, the photographs of the scene clearly show that she doesn't have abdominal distension. This is bowel distension, but could be a post-mortem phenomenon, and I won't consider this even to be pathologically enlarged, but it's definitely distended.
You commented on time.
Yes, sorry.
At the time of the injury causing the posterior nosebleed, and from there the blood then is swallowed, get into the stomach. Do you understand it correct?
Yes.
What time period are we looking at?
My lady, that's the question I answered earlier. I really cannot. And again, if we have to go to the Pistorius trial, and we all know the debate that was put forward in the court, and the court completely ignored it in its judgment because it's so unreliable to use the gastric emptying time. So I'm afraid, however much I'm going to be pushed, I'm still going to say I cannot tell the court.
Accepted. But it happened, the swallowing, while she was still alive, correct?
Yes, it has to be an active process. This is not going to happen passively in an unconscious or deceased person.
And in that process, do you agree that she could most likely cough or vomit, swallowing that blood?
Now, you don't. It won't necessarily lead to vomiting. If Mrs. Rohde has decided to swallow the blood will go down. It's not necessarily something that will be emetic. Clearly, there's evidence that she swallowed it, because when she swallowed it, it processed and went down the intestine. So the body didn't throw it out.
Now, you, as I understand your evidence, if one looks at the nature of the ligature mark and the vital action, the front of the neck, Blanche areas, liver parchment areas. We've spoken about that in quite some detail already. And you favored a hanging interpretation based, you start looking at that area. Do I understand you correctly?
Yes, just, Milady, I gave the court the reasons why. I said there are two competing causes of the neck pathology and why, on the balance of probabilities, I favored the hanging. A, on the presence of the ligature mark and the nature of the ligature mark.
Right.
Secondly, with the dribble of saliva, and again, the court has to decide on that evidence.
Right. And we've dealt with the aspect that the saliva, the evidence that this court has, is based on what the accused alleged saw. That's the evidence, the only evidence we have of that part.
Yeah, and that's why I made the last statement to the lady.
Now, I want to take you to Knights, the third edition, page 170, 171. We've referred to this authority, but I don't think you've got that particular page in the extracts that were handed up to court, so I'm going to hand this to court. That will have to be XXX, my lady, marked as an exhibit. I want to take you to the right top hand column. Another problem, the second paragraph that you've got it.
Yes, I do.
With differentiating ante-mortem from post-mortem injuries is the definition of the moment of death. Again, lawyers, judges, coroners tend to assume that death is an event, whereas in reality it's a process. And it refers to chapter 2. You comfortable with that statement?
Yeah. Like I explained in the pathophysiology, I think that's what Knight is explaining here.
Then, I quote further, thou in most criminal accidental deaths, the moment of death is conventionally and reasonably taken to be the moment of cardiac arrest and thus collapse of blood pressure and cerebral circulation. The cells of the body are still alive and remain so for a variable time. Only minutes in the case of neurons, but leukocytes and muscle cells survive for many hours, and connective tissue cells, such as fibroblasts, for days.
Yes.
Do you agree?
Yes.
Thus, it is unreasonable to expect dramatic changes within minutes in skin wounds, etc., until progressive hypoxia alters the biochemical process and enzyme activity. And what follows there. So, if one look at, I want you to take you to photograph 108 in Dr. Khan's autopsy, the post-mortem photographs 108.
If I can just comment quickly on
Sure.
this XXX. Basically what the author is saying, it can take time, even though the brain, and I indicated to the ladyship that the brain suffers anoxia and can die quickly. Within 3 minutes the brain can be dead, but you may have some cardiac beat, you may have some heartbeat. It may not be purposeful, but there may be some heartbeat. Now, I further added that most authors consider that the ligature mark is actually a post-mortem event, because that by the time the circulation ceases, there may not be enough time for the inflammatory cells to form a reaction. And that's really what this article is saying. I'm interpreting it in that way.
We're grateful for your opinion, Dr. Perumal. Now, you've got photograph 108 in front of you of the post-mortem Dr. Khan's photos.
Yes, I do.
Now, just where the ruler is on the right side, and I want also you to look at photograph 109 and
Photo 108, the ruler is on the left side of the neck. (109) also on the left side of the neck. 107 is on the right side.
now, yes, 109, 110, that area can you have a look?
Yes,
where
I have it.
I'm pointing.
Yes.
Would you agree an interpretation to that area can be that there's injury also below the ligature line? It differs from how the ligature line is coming from the middle of the neck to that part. Is that a fair statement?
My lady, I think if I don't want to interfere with counsel's reference to pictures, but if one looks at the corresponding picture in, I think this is Exhibit C, Annexure C,
Yeah.
photos 10 and 11, and Portal, remember I said always best to look at the earliest pictures.
Yeah, that was taken by
Jubin.
Jubin.
Yeah.
Photo number, which in Annexure C?
Annexure C, photos 10 and 11,
Yeah.
and one can see that if one follows the ligature imprint, it's, to me, it's that entire thing is part of the ligature imprint.
Yeah. Now, in photo 10, is it correct? It starts to thicken before it ends in the hairline. Can I indicate to you here on the photograph?
It's slightly thicker
Yeah.
than. Okay, let's look at the left side of the neck. It's a little bit thicker as one goes slightly to the posterolateral than on the actual lateral aspect. The ligature mark is never, and I know you should never use the word never, but never be the same throughout the neck, because you cannot predict the movements in the convulsion states that's going to cause the imprint.
Now, we see in this ligature mark blanche areas as well as leather parchment areas. Is that fair comment?
In photo 110, the post-mortem picture, there is one section there where the inch side of it is almost between 1 inch and 1.5 inch mark. There is a section here that doesn't have the leathery or the parched appearance, a leathery or abrasive appearance.
Now, could that parch areas be a result of an ante-mortem bruise, for instance, fingers being applied on the neck under that ligature mark?
Sorry, my lady, am I to understand that the parched areas, that is the areas that are appearing dark now,
Yes.
could they be from fingers? I don't think so. This is clearly a linear pattern.
But that's where what I perceive here, it thickens. It's not the same. I know you've given a explanation, but can't there be another explanation apart from yours? Or are you very exact that there's only one explanation as you've given it to us?
For me, there's a very, very high likelihood, a probability that this entire lesion that I'm seeing is ligature induced. But again, if you say to me, can I say to this court dogmatically that there wasn't a pre-existing injury from a digit and now we have an overlying ligature mark, I can't say that, but it just doesn't fit for me.
But could it be possible? Do you want to rule it out completely?
I think if I'm going to say it's possible, it's a remote possibility.
Now, your report, Exhibit JJJ, we've dealt with it in broad terms, and I don't want to belabor this point, but you were tasked by the defense to produce that report. Is that not so?
Yes, at the request of the attorney for the accused.
And that was some time later after your second autopsy, after you heard evidence in this court, correct?
That's correct.
And would you agree that in a certain way, subconsciously, as someone with lots of experience and also lots of academic experience, you're trying to test a version here, and subconsciously you're slanting towards a certain position, and that is on the version of the accused. You understand what I'm stating?
Yes, I understand that. Yeah. My lady, as I said, I'm standing before this court as a professional, as a scientist, expressing opinions, and I don't think any individual can say there is no bias or whatever it is that can creep in. But everything that I've said here, my lady, I've said purely on the science and logic. And however the versions can be put to me, I'll consider it and comment. But I think this is as objective as I can be in terms of drawing a report and commenting on the features in this case.
I want to deal with the feces that we see on the scene photographs, photo 4, photo 3, the front of the bathroom. Why do we see that? The photographs at the scene. Let me take you to the photograph number 4 and 5. We can go to Captain Ubaz as well. Let's just deal with photograph 4, marked B1. You've got that? It's Exhibit B. Where I should give you a copy of that. That was the first thing handed out. Before Captain Ubaz, photographs were put before court.
Okay.
Right. Now, photograph 3 and 4, you've got that?
Yes.
And it's B1.
Yes.
Would you agree that's a feces mark, specifically on photograph 4?
I'll say it's consistent, but I can't say that it is feces.
Now, we know from the evidence before court that no feces were found on her bathrobe.
Yes.
Correct? But there was feces as indicated in the paragraph 5L, the scene report of Dr. Khan.
Yes, I recall that.
I quote this: facial soiling noted between the buttocks, with feces noted under the buttocks. However, no fecal staining noted to the back of the bathroom door or to the gown. Now, what do we have to make out of this?
My lady, one of the changes that take place in an asphyxial there is sphincter incontinence. Like if the bladder is full, they can release some urine, and if there's a stool in the rectum, the stool or the feces can be released. It's involuntary. So the presence of stool between the buttocks, for me, is a further indication of an asphyxial death. Why there's no stool or feces on the gown or on the back of the door, it's unlikely to be on the back rear of the door. If she had a gown on, the gown should be stained depending on the amount of feces or stool there is. Lady, the only possible explanation for the stool as seen in photographs number 3 and 4, to me, is contamination. That somebody in the bathroom had stepped on stool and then walked out with it. I can't find any other explanation for the stool in this external area, B1.
I want you to look at Captain Dubert's photographs, Annexure A, as depicted photograph 2, photograph 6, the B1, photograph 7, the B1, that photograph 8, B2, photograph 10. Can you really say, Dr. Perumal, that it was transferred by way of somebody after the death, walking to the bathroom, coming out? Can we have an indication from what we see on the photographs whether there were step marks or footprints?
Yeah, if one looks at photo 10, one can see the swipe marks with photo 10.
This is now in Captain Dubert's.
Yes. To me, my lady, this is probably transfer, and you can see the white mark on it. I'm not emphatic about it. That's what I think it's probably.
Now, could that also not be possible, that it's transfer because of the body of Susan Rohde were carried, and in that fashion it was transferred? She was carried from the bedroom to the bathroom. Is that a possibility on the photographs here?
My lady, I'm not sure I saw photos of the stool soiling between the bedroom and the bathroom. I think all these are outside. I think.
Before you get to the bathroom.
If there was soiling present on Mrs. Rohde and she was carried and dragged over this area, then that could be transfer in that fashion.
Good.
Can you look at photo B3 for me?
Sorry, my lady?
Photo B3. Sorry, photo 3 and then...
Photo 3.
Yes, marked B3. That is outside of the bathroom door. Is that what you would be referring to?
Yes, that's what I'm saying, my lady. If the deceased had stool between a buttock and was dragged and the buttock was swiped along that area, that could be transference.
Do you understand this correctly that photo 10 is an enlargement of photo 3 and a particular B3 on photo 3?
Yes, but now the ruler is there, but it seems like it's a higher power of the same one.
Thank you.
And for that to happen, she was naked, correct?
The buttock area would have to touch the ground.
Yeah.
I don't know about the rest of the body.
Well, it is in dispute whether she had a gown on or not at certain stages. You don't have to speculate on that. I think you've made your comments on the gown and the lack of any feces on the gown, whether inside or the outside. Or do you want to say something more about that?
No.
I've got no further questions.
Thank you. Mr. Thomas Fowler?
Thank you, my lady. I would like to have that gown that was demonstrated, please. I'm sure it's available. It's one of the exhibits here. Because I intend to deal with it in re-examination. I can go on with other questions in the meantime, though. I'm happy to do that.
Thank you.
Whichever suits the court the best.
My lady, I'm informed and I recall now that it was specifically requested by Spear that we return that. It's a brand new, very, they want to use it, but certainly we can have it here within an hour or so, such gown, my lady.
Okay. Maybe I will adjourn for a few minutes. It is now almost 11:10. It's close to tea time anyway, and I'll
We'll make
give you an
arrangements.
opportunity to discuss it by between each other. Thank you. We convene after tea.
Court, please.